All rise.
Following case involving the following minors, the Austin minors, Madison, Marcus, and Michael, 14099NA. It's the first time I've been involved with this case. I think it's been heard by the referee a couple of times. He's probably listening on behalf of the department. Mr. Danielle is here on behalf of Dad. Can you state your name, sir?
Very awesome.
Okay. And is it Mr. Lamb?
Mr. Lambert, Your Honor, good morning.
On behalf of Mom, can you state your name?
Danielle Austin.
Okay, well, we're here today because, Mr. Barbieri, our lawyer guardian ad litem is here. We're here because Mom apparently filed a motion in council. Have you had a chance to talk to your client about this?
Your Honor, I've had numerous discussions with my client. Yesterday, I learned of this motion yesterday when I received the fax terminating me. I learned there was actually a motion at 4:45 last night. Although we have had opportunity to discuss some of the content of the motion, which I just received this morning in the past, I have advised my client against it. I have discussed this in detail with my client, which raises a point actually as a procedural matter. With the court's permission, prior to the arguing of this motion by my client, frankly, I'd have to move to withdraw, Your Honor. There's definitely been a breakdown of the attorney-client relationship here. My client has sought to terminate me more than once. This is the third time, frankly, all within the last week or so. She's failed to heed advice of counsel, and frankly, I'm disappointed. She was doing well in this matter during the dispositional reviews until about a month ago. She had parenting time.
Well, now, we can't have anyone in the audience talking while the attorney is talking, so everyone please be quiet. Go
She
ahead.
had parenting time, Your Honor. That has gone backwards. Currently, at this point in time, she believes she's being persecuted. She believes the government is after her. She believes there are conspiracies left and right. She believes that something may happen to her, which was a discussion at the last dispositional review. She believes that her children have been kidnapped, et cetera, et cetera. Her rights have been violated, both federal and state.
No, I really object to all this.
Just wait, I'll give you an opportunity to talk, but let your attorney speak. Go ahead, counsel.
Your Honor, the proof is in the pudding with regard to the unilateral filing of a motion, which we had discussed in general. She's raised some of these issues with me, and I've explained how it works. I've explained to her that there's really no merit in the arguments. Nonetheless, she's filed the motion. She's entitled to do that. But I don't see how I can, in good faith, represent her, given that my assignment is to assist her in reacquiring her children. This is counter to that. As an officer of the court, I certainly would not have filed these motions for reasons well known to the court. I believe that these motions simply do not help her. She's entitled to make what arguments she would like. I don't see how I can assist her. Frankly, there's been a lack of communication substantively with regard to the case other than being terminated. I don't see how I could realistically be expected to represent her when she's not even sending me motions that she unilaterally files on her own. Fortunately, I had time this morning and could drive up from Grand Rapids to be here today. This also puts me in an awkward spot. To the extent she proceeds in this course, which there's no reason to believe she won't, the outcome with regard to the children is obvious. I don't wish to be accused of not representing her zealously simply because I disagree with the approach that she wishes to take. I think the best thing that could happen for my client at this point is that she get another attorney, and I've discussed this with her. Get another attorney. Hopefully he or she will tell her essentially the same thing I'm telling her, and maybe after she has an opportunity to hear it from 2, 3, or however many attorneys it takes, she could get back on track with regard to the reunification of her children. So at this time I make my motion. I don't frankly see how I can argue this for reasons discussed, and frankly I don't follow the logic. Thank you, Your Honor.
All right, ma'am, your attorney has basically indicated that he'd like to be withdrawn from your case. Any objection to that?
No.
Okay, sir, I will sign an order letting you out of the case.
I will present one forthwith, Your Honor. I would have brought one, but as indicated, I did not really learn of this motion till quarter to 5.
Very well, you're free to go, sir.
Thank you,
Thank you for being here. Ma'am, I'm gonna let you argue your motion. I'm also gonna be asking you if you would like the court to give you a court-appointed lawyer for this proceedings.
No, I do not.
So you wish to represent yourself?
Yes, sir.
Okay. Well, why don't you go ahead, ma'am, and argue your motion? Go ahead.
Well, first off, Your Honor, I'd like to confirm that you are operating on your oath and bond.
Pardon me?
I would like for you to confirm that you
I'm
are
not
operating.
going to answer any questions for you. You can argue your motion, go ahead. You're not asking me a thing.
Okay. Well, I feel that everything that was stated in my motion is pretty much clear. There was a lack of service and, due process, that my rights were violated. I mean, I came into court and I didn't know what was going on or what the allegations were against me.
I read
They
the
had-
file. Isn't it true you made admissions in this case, ma'am?
Yes.
Continue.
But everything happened so fast and there weren't emergency circumstances to do that to me. I mean, to have proper lawful notice, so that way I know what's going on in the case. I can get my own attorney and have the time, to be able to prepare my case, which there wasn't. I was notified 2 hours before it was time to go into court.
You talking about the original emergency hearing?
Yes,
Okay. It was sometime after that that you actually made admissions after you retained your own attorney, is that correct?
yes, sir.
Okay. Anything else you'd like to add regarding your motion?
No.
Ms. Scully, anything you'd like to say regarding her motion?
Just, Your Honor, I noticed what the court has pointed out, there was a preliminary hearing commenced on July 23rd. The attorney was provided for Ms. Austin. That hearing was adjourned until 29th, but in the meantime, on the 23rd, the court did order placement with the DHS. And then concluded the prelim on July 29th, that's when the petition was authorized. And then again, as the court pointed out, on August 6th of 2014, Ms. Austin with her retained and maintained admission. So I don't think there's any alternative other than for the court to dismiss this motion or deny this motion.
Mr. Brumell, any comments?
No comment.
Mr. Barber?
No comment, Your Honor.
Okay. Anything else you'd like to say, ma'am?
I don't know.
Okay. Well, your motion has no legal merit, okay? It just doesn't. It's nonsensical. Doesn't make any sense. You had a retained lawyer when you made admissions. You could have gone to trial. You could have asked for a jury trial. Prosecutor would have had an obligation to present a case and convince a jury that your kids fell within the jurisdiction of the court. But for whatever reason, you made admissions, the court accepted jurisdiction in this case. The court has jurisdiction in this case. There's no merit in your motion, and your motion is denied. Now, I don't know if you have the capability of representing yourself in the future, but I'm gonna appoint the Isabella County Public Defender to have a lawyer present for the next court hearing we have. And you'll have to talk to that person, and you'll have to decide if you wanna represent yourself. But at a minimum, I'm gonna have a lawyer sitting at the table with you to guide and help you if needed. So between now and your next hearing, when's the next review hearing? Between now and April 13th, we'll have a new lawyer appointed. You'll have to meet with the attorney and figure out how you wanna deal with your case. But I'm not gonna have you come into court on your own, trying to represent and litigate your own interests when the other side has a lawyer and when everyone else has a lawyer. You need to get advice from a person skilled in the law. So that's the order of the court. The motion is denied. Ms. Scully, please prepare an order that the court sign.